Welcome to Crime in Court. My name is Heather, and this is an update in the Delphi case. So, just recently, we got an order, a writ, I don't know what you call it, from the Supreme Court stating that they were not going to take Judge Gull off the case, which is a huge mistake, in my opinion. For whatever reason, they cited some uh, saying like because they filed other motions that I don't know something they waived their time limit because they filed like a lazy judge rule and she wasn't ruling on the fourth Franks or the Franks memorandums and she kept pushing it down the line. So this comes after that. They probably had these, this was probably their plan if they received a denial from the Supreme Court, which they did. So this is the defendant's reply to the state's response to the defense's fourth Franks motion. So the defense filed a fourth Franks motion. This was about the geofence data and the report basically stating that Richard Allen's phones weren't in the area where they said that the homicides happened, and there were other phones in the area that were. So pretty much exculpatory evidence that was also, I believe, hidden. They didn't find this out until recently. So that's another reason this discovery keeps coming piece by piece and buried in other things is the important stuff. So this is, so the defense filed their fourth motion and then the state responded. And now this is the defense's response to the state's response. That makes sense. But they have some really great points, and I think it gets a little spicy. All right, so let me make this page bigger. It's like an odd size. All right, so comes now Richard Allen by counsel and files his reply to state's response to defense's fourth motion for Frank's hearing. In support of said reply, the defense states the following. Number one, on April 29th, the accused, Richard Allen, filed a new request for a Franks hearing based upon new evidence. Number two, said request was the fourth Franks notice filed by the defense. Number three, in said request, the defense detailed newly discovered evidence herein called the Blocher report that suggests that the phone that was found at the scene where the phone that was okay. So the phone, the victim's phone that was found at the scene where the victims of the homicides were ultimately found on February 14th, 2017, had actually been taken out of the area on February 13th before being brought back to the area at some point in time on February 14th. So this report, not only does it have other cell phone data in the geofence area, but it also has the victim's phone moving from that location where they were found and then being brought back to that location where they were found the next day, which is huge because the prosecution is saying that the place where the girls were found is the place where the homicides took place and at that time. And there was no time in between. It was when they were abducted, they were immediately um, taken to this spot, and then that was where the homicides took place, according to the prosecution. And there is evidence now to suggest that the girls were taken somewhere else and then brought back to the scene where they were found. There's multiple pieces of evidence or reasons to believe that, but this really helps solidify that is likely what happened. Number four, the prosecution turned over the Blocher report approximately 14 months after the state was required to turn over the evidence. See, late discovery and hiding it in important stuff. Like I said, some of the defense has complained that the way that the discovery is being handed over to them is very complicated, organized in a very convoluted manner, and even when they're looking for something and asking the prosecution for it, they have a hard time looking for it. So that's a big part of the problem. also. And one might wonder, are they doing that on purpose to make it seem, to make, if they have a bad case, are they doing that on purpose to hide the exculpatory evidence for Richard Allen in just a boatload of documents and discovery where it may never be found? It's a good assumption that they might be doing that. All right, so turned it over 14 months after they were required to. This newly discovered evidence shows that on February 13th, 2017, one of the victims' phones were outside the area of where the bodies were ultimately found. Judge Diener had a right to know this information before issuing a search warrant, as said evidence completely throws off the state's timeline of events, thereby exonerating Richard Allen. So that's really important. Important evidence here that was buried. All right, so number 5, this is important because law enforcement have maintained from the beginning of the case that the girls were their lives were taken on February 13th, 2017, and remained in the place that they were found from the following day, never leaving the area where they were ultimately found. Like I said, that's the state's theory. They were taken to this spot where they were found, their lives were taken, and then they were left there. But searchers were through that area after the time that they went missing. So it's kind of also it strains your imagination there because you'd really have to use your imagination. All right, to make that work. Number 6, the new evidence, therefore, would show that the phone and the victims were taken outside of the area where they were ultimately found, but then brought back to the area at a later time. Number 7, in his response to the fourth Frank's request, the prosecution, Nick McClelland, makes several assertions that simply aren't accurate or true. We all know that, but uh, I'm glad he's pointing it out for the judge because she doesn't. And she likely won't believe that this is true, this statement here, number 7, but, she's on the prosecutor's side anyways. All right, so number 8, the prosecutor is not a digital forensic expert, and his assertions should not be accepted or true or accurate by this court until he presents evidence and or testimony that supports his assertions. So just because Nick McClelland says that's not true and the girls' phones they never moved, if that's his theory, well, prove it. Show us something that proves that. Don't just say it. Saying it doesn't make it so. Number 9, similarly, the defense attorneys are not digital forensic experts as well, and therefore the defense would also request this court to not accept their assertions as fact. That's brilliant because they're saying, we don't know and he doesn't know, so let's ask an expert. Number 10, rather, on such an important issue as to whether law enforcement failed to inform Judge Diener, I always say Diner, it's Diener, concerning evidence related to the timeline that would have indicated to Judge Diener that Richard Allen did not commit the homicides. Let me read that again because I flubbed that. On such an important issue as to whether law enforcement failed to inform the judge concerning evidence related to the timeline that would have indicated to Judge Diener that Richard Allen did not commit these homicides, the defense would request this court to set a Franks hearing to hear both sides before making any determinations. Beautiful. She's going to say no anyways, but it's beautiful. It's a good argument. It's a very solid argument. We're not experts. The prosecution's not experts. Let's have a Franks hearing. That's the whole reason we're asking for it. Number 11, simply stated, through the pleadings filed by both sides, two competing narratives have formed. One, the state of Indiana disagrees with the defense's interpretation of the digital forensic evidence and the Blocher report, while two, the defense disagrees with the state of Indiana and its interpretation of the digital evidence and Blocher report. Number 12, A hearing would allow the court to listen to the evidence and draw its own conclusions from the evidence, rather than believing one side or the other on these issues of the cell phone pings and the Blocher report, as this court has little or no context concerning the facts to make any decisions, nor presumably the expertise to make such a decision based solely upon pleadings filed by each side. So now they're saying, Judge, no offense, but we don't think you're an expert either. So let's just bring in the experts to tell us what the data says. Wherefore, the defense requests that this court to simply not accept the prosecution's nor the defense's assertions concerning pings and the impact of Sergeant Blocher's report, and to set this matter for a hearing where the court can hear direct testimony of state and defense witnesses subject to cross-examination before making any rulings on this important matter. Signed Andrew J. Baldwin, and that was filed the 23rd of July, so just yesterday. Sorry, I want my coffee now. So that is the first filing that we're going to go through. These are all really short, so this is going to be a short video, just FYI. So what do you guys think of that? I think Judge Gull, it kind of forces Judge Gull to set a hearing, but knowing her, she might still just say no and no hearing, denied without a hearing. But she has said to the former defense attorneys that she assigned that she would schedule a Franks hearing if necessary. She said if they felt that way, if they looked at the evidence and determined that they should go with the same strategy as Andrew Baldwin and Bradley Rosie. Um, yeah, she still has not given them their Franks hearing, and it makes you wonder. They've asked now 4 times with multiple, you know, nudges and supplemental things that went along with these motions. So it's not like they haven't been asking for this. She is just denying or ignoring it. She's ignoring it. It's a lazy judge rule. She's just ignoring their filings. So the next filing I'm going to read is the defendant's motion for leave. Sorry, my dog's making noise. All right, so the defendant's motion for leave to present mini opening statement to the jury panel prior to voir dire. So even before they do their jury selection, he wants to present just, some facts about the case uh, to kind of gauge where they are and to give them some background because there's a lot to this case if you are really looking at the court filings and not just listening to the media and what they're telling you. So, all right, so comes now the defendant by counsel and moves this court for leave to present a mini opening statement to the jury panel prior to the commencement of voir dire, and as a basis for such motion states, number 1, Indiana Jury Rule 14b provides to facilitate the jury panel's understanding of the case with the court's consent, the parties may present brief statements of facts and issues, a mini opening statement, to be determined by the jury. That's kind of cool. I didn't know that existed, but I like it. But you have to ask permission, and this is Judge Gull. But that would mean that the state gets to present too, not just the defense. So I would think that this would help the state as well. Number 2, the defendant asserts that their right to a fair and impartial jury, as constitutionally guaranteed, will be enhanced by this procedure because a more meaningful exchange of information will take place during voir dire if the parties are allowed to preview the main issues to be contested at trial. It'll probably speed things along too, I would think. Number three, the defendant believes that those issues can be effectively summarized by each party pursuant to Jury Rule 14b. So they're advocating for both sides to have a mini opening statement during or prior to jury voir dire, according to this rule. And he's asking for 3 minutes or less. Wherefore, the defendant, by counsel, respectfully requests the court permit a mini opening statement by each party immediately prior to each party's first round of voir dire, and that the court determine the amount of time allotted therefor. The defendant further requests that any time given by the court for mini openings not be deducted from the time limitations the court sets for conducting voir dire. Yeah, so don't take my 3 minutes out of it, okay? Let me have my 3 minutes, lady. Signed, Andrew Baldwin. And what do you guys think? As long as the um, state doesn't contest it or object to it, whatever, um, then I don't see why she wouldn't approve this. But who knows? Who knows? Because this is Judge Gull we're talking about. And finally, the last thing I wanted to bring to your attention was just this data that was entered on July 22nd into the docket for Richard Allen. It says transport order entered. This is all we know. It came from Judge Gull, and it was 7/22/2024, a Monday. So that's all we know about that transport. Why can't I speak? Transport order. And I maybe we'll see some more paperwork on this hopefully in the future, but I don't know. And usually we haven't been finding out about his transports from one jail to another until after the fact. So was this for a hearing? I mean, there wasn't a hearing this week, so I don't know. It has to be potentially being transferred to another prison. Maybe they're moving him back closer. I don't know. Hopefully, they're keeping him safe and keeping him away from the guards that are threatening him and his family. So, that is where I will leave you guys. Thank you so much for tuning in. Please hit the like button. Let me know in the comments below what you think about this trial. What do you think about Judge Gull? What do you think about the defense's motions, especially in response to the defense in the Frank's requesting a Frank's memo or Frank's hearing? Let me know in the comments below, and I will see you guys in the next one. Thank you so much for watching. Take care. Bye now. If you've been impacted by a true crime and would like your story told in your own words, or if you or someone you know has been wrongfully convicted or accused of a crime, please write to crimeincourtchannel@gmail.com and tell us your real true crime encounters. Thanks for watching.